So my So my court case was on the O'Bannon versus the NCAA and CLC in 2009. This case dealt with antitrust laws, which are federal law that regulates interstate commerce in effort to prevent organizational monopolies. Price fixing is an example of a violation of these laws, and they use the rule of reason test to balance those illegal practices against the anti-competitive effects that they give off in order to analyze these cases. So the explanation of the case is the issue here is the NCAA's amateurism compensation model subject to antitrust laws, and if so, are they an unlawful restraint of trade? The plaintiff was suing the NCAA because of his belief that they were illegally using student athletes' likenesses and images in different things like DVDs, video games, photographs, apparel, and other material, and they were never seeing any compensation for it, either as an athlete or as a former student athlete. The plaintiff was Ed O'Bannon, who is a former UCLA basketball player. He won the national championship with them his senior year and also went on to have a NBA career as well. And the other members of the plaintiffs, Sam Keller, as well as a group of 11 former basketball and football student athletes that I'll get to a little bit later in the presentation. And basically, the plaintiff was seeking damages from the NCAA to pay former athletes for illegally using their likeness in order to make a profit. So not only were they searching for these damages, but they were also searching for an injunction to bar the NCAA from using their student athletes' licensing rights of their images any longer. The defense was the NCAA, the National Collegiate Athletic Association, who is the governing body of intercollegiate athletics. The CLC, or the Collegiate Licensing Company, which was a company that's hired from the outside to deal with colleges' licensing agreements and different things like that, as well as EA Sports, who was a video game manufacturer. And they made the NCAA football and NCAA basketball video games, which was a main pillar in this case. So applicable elements of case. So the case was combined with Sam Keller's. Sam Keller was originally suing the NCAA and EA Sports on very similar grounds. So they ended up combining their cases together. And then a year after that, they also added those other former basketball and football players to the case as well. Then in May 5th, 2011, EA was actually dismissed from the case, and they were dismissed because the judge cited there was no evidence to prove that they were actively conspiring against the players to not compensate them from using their likeness. Applicable elements, plaintiffs changed strategies, so not only were they seeking damages for the former players, but now they were also seeking for current student athletes to be part of the equation to receive those revenues made from their media and licensing deals. That money would then be put over into a trust and held on for the athletes until they graduate in order to still be consistent with the amateurism rules that there are in college sports. And then the trial progressed, and then Sam Keller's lawsuit was separated from this case and set for a new trial date as well. And it kept progressing, and then the plaintiff ended up stopping pursuing the individual damages and pivoted towards the antitrust case to drastically change the current NCAA model. They didn't see that going after individual damages was going to be worth it, so what they wanted to do was have to force the NCAA to change their restriction and their rules, and that would really change the model that the NCAA has still to this day on how they go about student athletes and their likeness. The NCAA proposed 4 pro-competitive benefits that was in support of why these restrictions were in place. The first one is the preservation of amateurism as an essential component of intercollegiate sports. It was to the NCAA's belief that the popularity of this sport and throughout the fans were because they were amateurs playing and not professionals. And they cited things like surveys and different things to make their point there. However, the plaintiff's response to that was that that wasn't part of any systematic study, that their claims that because they're amateurs and not paid is what fuels the fandom, as well as they pointed to an organization like the Olympics, which actually gained popularity when they changed their rules on amateurism. The second pro-competitive benefit had to do with competition, promotion of competitive balance in intercollegiate sports. It's important for financial viability of the sport, and what they pointed to, the NCAA, was different leagues that use salary cap and other restrictions to promote competitive balance. However, the plaintiff's response to that was that it isn't actually a totally 100% balanced league is what drives fans. It's quoted absolute quality of each team and intensity of demand for winning among fans of each team, which was based off of research by Fortin Quick in 2010. So it kind of discredited that a totally level playing field is what gets people there, as well as other research shows that if athletes were paid the same amount by all the colleges, they would still have the same decisions they had to make as if they weren't getting paid. They would choose a college based off of coaches, facilities, other things like that. So it isn't really throwing the competitive balance out of whack. The third pro-competitive benefit was the integration of athletes into academic and social life, and the NCAA made that argument based off of their surveys of personal experiences from NCAA officials and other colleges. However, the plaintiffs respond that first, they cited research that they proved academic success actually directly benefits from having financial security. So the plaintiff said that if you are actually making these scholarships more valuable, it actually will enhance the academic success of students in their studies to prove that. They also believe that financial security helps with the integration of athletes into academic and social life. The fourth pro-competitive benefit is the generation of surplus funds to spend on women's and minor men's sports. The NCAA argued that cutting those revenues would result in athletic departments having to cut the sports that don't have that surplus of output like football and men's basketball do. However, the plaintiff responds that, one, the NCAA, the way their financial reports are set up, they cannot illustrate the extent of surpluses, so that couldn't be proven, as well as they revealed that the rising participation in football and basketball also showed declining participation in other men's sports from 1980 to 2011. So the NCAA's own study ended up contradicted them and showing that how it's actually limiting opportunities for those other minor sports. The results of the case, the district courts first made their ruling, and what they ruled was they rejected all the pro-competitive justifications from the NCAA. They said the scholarship should be raised to include cost of attendance. They should also allow schools to put some portions of licensing revenue into a trust for those athletes for when they graduate. However, they rejected the proposal to allow third parties to be involved in that licensing with the student athletes. This court case then went to the Ninth Circuit Court of Appeals, where they unanimously upheld the cost of attendance ruling by the district courts. However, by a vote of 2-1, rejected the licensing revenue and trust for athletes. They didn't believe that would have any pro-competitive effects. That would actually have the opposite. But however, when this was going on, the power conferences already, because this case took time from 2009 to 2015. While this was going on, the NCAA ended up incorporating into their bylaws that cost of attendance would be incorporated into their athletic scholarships. So the result of the case, by the time it finally was decided in the appellate division, this was already implemented in the NCAA. Two similar cases. The first is the NCAA versus the Board of Regents, which was when the NCAA was first negotiating their TV contracts, and basically they negotiated this contract and told no other schools were allowed to negotiate independent contracts. And then the College Football Association, the CFA, which had a bunch of different football-centric schools, went out and negotiated their own contracts, and then ended up going to the court. And what the court ruled was the NCAA was in violation of the Sherman Act. They were acting monopolistic, manipulating the market in order to raise their value on their tickets, and that was very monopolistic and in very much violation of the Sherman Act. And the last similar case was Law versus the NCAA, and the NCAA passed a bylaw that limited salaries of assistant coaches, and what they did was they sued that, and they said limiting that was price fixing, which is in violation of the antitrust laws, as well as violation of the Sherman Act because it constituted a restrained trade. The court ruled that if the NCAA couldn't prove this law's pro-competitive effects, that it would then be found that it's in violation of the antitrust laws, which they couldn't do. So they're no longer allowed to reenact those compensation limiting rules like the one they had for coaches. Thank you.